Ooh, people are rallying now. I guess that'll undo Trump's pick for the Supreme Court. I'm Mark Greenstein. This is a follow-up for the Daily Fire. Rallying in the streets has never impressed me. In fact, it tends to turn me off because I perceive that people are acting with emotion instead of reason. I'm a fan of the cerebral helping us rule far more than the emotional. When you have to resort to rallies instead of pens and keyboards, I have the suspicion that you're resorting to bad arguments. So I'm not impressed. And rallies in the last decade have brought us almost the opposite. Street rallies by progressives in the last decade, where has that gotten you? I mean, Occupy Wall Street, 2011, 2012. Did that change Wall Street practices? No. Firms have gotten bigger and richer and more selective. Black Lives Matter, with rallies after every incident that on the surface looked unfair, and it has turned so much of America against you. So here comes rallies against Trump's nominee for the Supreme Court. And I just want to make sure people realize that the thought behind it is lacking. You don't recognize that the Constitution gives the prerogative to the president. Congress is supposed to approve, advice, and consent is the power that they have. To unapprove any single pick by a president over and over and over, which is what Murphy and Blumenthal have pledged, is not within America's founding document. How about a more productive rally with pens and keyboards and maybe some cerebral videos like this one to just explain how you actually do have the power to counteract bad rulings by the Supreme Court? You're so fearful. Let me get into why you shouldn't. A Supreme Court has very little power if a legislature, Congress, or a state legislature steps up. And states have the power to step up in almost every single area. Incorporation is not an absolute doctrine. It's been accepted, I think wrongly, for federal rulings to apply to states. I think it's a bad doctrine, and it's certainly not what the framers intended. So let me apply it to the very few things the Constitution applies to state governance. It says in Article 4, no state shall enter into a treaty, grant letters of marque and reprisal, coin money, emit bills of credit, pass laws impairing contracts, grant a title of nobility. Later on, the Constitution says no state shall lay imposts, that's tariffs, or engage in war, unless actually invaded or in such imminent danger as will not admit delay. Absolutely reasonable and beautiful. And notice, aside from these prohibitions on states acting, states can do what they want. So whether that is abortion that some people are afraid is getting diminished, or on the conservative side, Obamacare, which you've left in the hands of judges. You waited for John Roberts and 4 other colleagues to eviscerate Obamacare, and it didn't come. Guess what? The Congress could end Obamacare tomorrow in one sentence. Have them step up. In Connecticut, a legislature that is empowered by people to undo or refashion a ruling that seems to be coming from the feds has the power to do it. There are very few amendments that restricted that power, none in the first 10. It takes 13, 14, and 15. These are the Civil War amendments that explicitly apply to states not being able to block voter registration, block blacks from voting, block slavery, and give equal protection of the laws to newly freed blacks. 13, 14, and 15. One more, that's the 19th Amendment that applied to states. No state shall prevent women from voting in elections. States can do almost anything else. And so, for the second time, I am imploring people who are upset with judges to stay upset and to counteract it with reasoned legislative proposals that you, through your representatives, have the power to enact. Some of you have strong enough governors with the power to either push for legislation or stay away from certain things that don't have to be followed. I plan to be one of those governors here in Connecticut until we have a robust General Assembly that really follows the will of the people. I'm doing it for you. Unelect me if you want. But that's what you're getting for 4 years until a General Assembly steps up, and I'm going to be squashing rulings of judges that are not elected when they are not appropriate as legislation. Judges are there to interpret. Judges are not here to legislate. That should give all of us comfort and all of us a more sense of power. I'm Mark Stewart, and I'm in your corner. Thank you for being in mine.